Hi, my name is Kim Heinrich, and I handle marketing at Meritas headquarters. I would like to welcome all of you to today's Meritas Capability Webinar, E-Discovery Strategies and Trends. Today's webinar is scheduled for 60 minutes, and our presenter is Meritas member Margaret Raymond Flood of Norris, McLaughlin & Marcus in Bridgewater, New Jersey. Margaret devotes her practice to complex commercial litigation and co-chairs her firm's Response to Electronic Discovery and Information Group, also known as READY. And the READY group is an interdisciplinary team that helps clients with the identification, preservation, collection, review, and production of electronically stored information as required by federal and state court rules. Margaret is also a member of the steering committee for Meritas' litigation group here. Now, before we get started, I would like to walk through a few housekeeping items. As you have all likely noticed, your phone lines are muted, and that's just to best manage our calls. However, we encourage you to submit questions to Margaret through the chat feature, and you can do so right at the left-hand side of your screen. Enter in a message at any time during the webinar, and that will go directly to Margaret. Should you have any technical issues, you can hit *0 directly from your phone, and someone will be on the line to assist you. So with that, Margaret, are you ready to get started?
I'm ready.
Great. Take it away. Thank you.
Sure. Thank you, Kim, and thank you, Crystal, for helping me with the technology piece of this. Before we get started, one of the things that I thought was would be helpful to all of us on the call is to sort of get a sense of who we have on the call and what your involvement in e-discovery has been to date. So if you would, click on the slide that's just popped up, which is, have you been involved in complex litigation involving e-discovery? The responses are starting to tally already, so I see that some of you have already responded. And I would just ask for those who have not yet to do so, so at least we can sort of figure out the audience that we have. It looks almost evenly split with 9 yeses so far and 6 noes. And then the next question, which I think will also help gear us, is the next slide, which is slide 4. Whether you've used technology-assisted review or predictive coding, which we'll get into at some length as we get into our presentation today. Okay. So it looks like we're having more no's than yeses, which is what I assumed because, frankly, it's so new and upcoming and cutting edge that most of us have little, if any, experience in that area. So, okay, so let's get started. When the rules were amended, and by the way, just as an aside, because we have attorneys from all different states, I'm really going to try to keep this presentation as general as possible, and really what I'm basing my presentation on are the federal rules. Most of the at least as to New Jersey, most of the state rules are directly taken from the federal rules, and I can't say that I am an expert in every state, and frankly I have not looked at all of the rules in all of the states that involve some of the areas where you guys all practice. But I just want to let you know that the bulk of my presentation is taken from the federal rules, and certainly we can modify it if there's a specific question on a state rule. I'm not sure that I'll be able to answer it, but I'll certainly do my best. When the rules were changed, and we'll deal with the federal rules primarily, there was a big question at that time, a few years ago now, as to what the rule changes meant to us as attorneys and what it meant to our clients. And back then I was saying, really it means nothing different than what you were supposed to always be doing. But at the same time, I would say, and I still believe, nothing really changed, yet everything changed. Because it was the same set of rules, it just incorporated a different body of information. So while documentary and other evidence had been previously lost before, the presence of the electronically stored information now heightened the risk. And it heightened the risk for a number of reasons. One, because there's just such a greater volume of evidence to manage now. You know, the statistics are just earth-shattering in terms of how many documents you can keep on very small devices, little zip drives, CDs. You can keep boxes and boxes and boxes of documents on something that you can put in your pocket. So now all of a sudden the volume of evidence to manage is so much greater. The inadvertent and the planned destruction of electronic information is also something that's new and we have to deal with on a day-to-day basis. It used to be that documents were kept in a file cabinet and they would get dusty, and when you wanted to go to the documents of a particular company, you would go to the dusty archived folders, pull them out, make copies, and that would be it. Now it's different. It's not as easy as just going to a file cabinet. And so the new formats and the various storage locations electronically make our job just trickier than it was before. So when the early decisions on electronic discovery came out, and everybody knows the big names, the Zubilacki case, the Coleman Holdings case, the Phillips Morris case, it sent shockwaves because of the numbers and the dollars and the sanctions, and it made everybody sit up and pay attention. And since that time, it's really been a continual work in progress. And for all of us that have been involved in it from the beginning, it's really interesting to see the peaks and valleys of the electronic discovery cases and the law and how it's changing as we're moving through it. And frankly, I think as we're all just figuring it out. And of course, it's a moving target because as technology changes, of course, our obligations under the technology are impacted to a certain degree, and we need to figure out on an almost daily, weekly, monthly basis the best way to handle various issues that we're now coming across, particularly in litigations involving electronically stored information. So one of the things that I want to try to focus on today is what we need to do, how should we approach the challenges of information management and e-discovery, and to talk a little bit about some of the strategies that at least I think are good ways to handle it. Now, every client, in my mind, is different, and I think every time you pick up a file, there has to be some unique approach to a certain extent, but I also think that the overarching plan really is the same. And from my standpoint, I like to say that I handle the phases of electronically stored information in 3 distinct categories. 1 is the planning phase, 2 is the preservation phase, and 3 is the collection and production phase. And I'm sure any speaker would get up and maybe could add different phases and could modify and all of these to a certain extent. But I think they really do fit into 3 nice buckets. So let's talk first about the planning phase, what I mean by these phases. The planning phase, in my mind, is pre-litigation, before anything happens, or upon learning of a litigation of a potential claim. I would classify both of those in the planning phase. If you have a client that you work on all the time, it's a client that you handle a bulk of their work, the planning phase, frankly, is a little bit easier because I think you can take affirmative steps to work through some of the issues before litigation hits, before there's a problem. It's not so easy when you're brought in or retained as counsel once litigation has happened or upon the learning of a potential claim, because at that point you're a little bit behind the 8 ball. So let's talk first about how to handle it from a planning stage before anything happens. You have a client who you've done a lot of work for. One of the things that I really recommend and we try to do here with our clients is talk them through their e-discovery issues before litigation starts. Make sure they have protocols. Make sure that you understand what the client, how their systems work. Make sure that they have everything that they're doing in writing and that they're actually following it, so that when litigation hits, it's an easy transition. If the other instance is upon learning of the litigation, that's when you have a lot of quick legwork to do. And we're going to get into both of those in a few minutes. Preservation, what I consider preservation is, and we'll spend a good deal of time on this in the next hour, is in my view, the most significant. And the reason that I say preservation is the most significant is because for us as lawyers, I think this is where we have the most exposure. If we don't do the preservation portion of the electronically stored information in the litigation the right way, that's where you're seeing the sanctions. That's where outside counsel is becoming liable for not having instructed their client the right way. Collection and production is obviously very important at the litigation side, and some would argue, I think, with me to say that collection and production is the most significant issue, but I don't think so. I think it's the preservation piece that's most significant to us as lawyers in terms of making sure we've handled it the right way, because it's the one area, frankly, that you can't fix. Once you fail to preserve and the electronic information is deleted or gone or purged, you really can't get that back. Unlike collection and production, if it's preserved properly, even though it will be more costly, you can always go back and reproduce or recollect or do it a different way, use different search terms, etc. So in my view, there's a way to fix collection and production. There's not really a way to fix preservation once the documents are gone. So I think we spend so much time dealing with the collection and production phase of it that sometimes the preservation phase gets away from us a little bit. And I think that's one of the things I want to focus on here today. It's a natural step, the collection and production phase, once the preservation is done properly, and I think it makes life much easier for all of us. So let's talk about the planning phase. Phase 1 of ESI, the planning phase. It's so important to assess and understand the information management in each of the individual clients. And frankly, in my view, no two clients are the same. Everybody does it a little bit different. And it's very important, especially when litigation hits, to know exactly where you have to go. So if you have a client that's a long-term client, and if you can convince the client that it's important enough, one of the things that I think is significant is to make sure you have an inventory of all the various storage locations, the document types that your client worked with, categorize them and catalog them so that in the event litigation happens, it's a quick, easy step to get where you need to get for the preservation phase. If you've done all the legwork of what the client has and where everything is stored and how they work their systems ahead of time, it's a lot less stressful. That's obviously the perfect world, and most of the time we don't have that option. But in the event that you do, I urge you and encourage you to try to do that ahead of time. And if anybody needs, I have protocols, and I've sat through with clients and gone through this before litigation. And frankly, I have some clients that we've done it for who have never had a litigation, but they're ready if they have to be. And then we have others who are in the middle of 3 and 4 litigations and have no process in place at all, and you can't get them necessarily to pay attention to it until the litigation hits. So it's certainly at least an area that you can offer to a client, and oftentimes it helps tremendously down the road. And then, of course, there's developing of document destruction schedules based on the business needs. And what I always tell everyone is, if you have a document destruction schedule, make sure you follow it. If you're not following it, don't have it. There's nothing worse than having something in writing that you're not complying with. Explain that to the court. That is no fun. So where do we find electronically stored information if we're assessing and understanding the information management? It's everywhere, right? And we see it all day long. It's in the phones, it's in the servers, it's in the printers now, it's in the copiers because of everything that's stored. PDAs, it's on CDs, it's on thumb drives. So when you're going through with your client where documents may be living or where they are, you really need to take them through all the various areas. Now, obviously, there are certain clients, for example, who have a lot of field reps. Field reps have laptops. Field reps have PDAs. That's a very different scenario than a company that sits in their office all day and they work off one main server and they have individual computers or whatever they do. So it really is, I think, unique to each client, how they work and where they do things. And it's really important to understand that when you're trying to put preservation and collection in place. And then, of course, there's some other devices that we sometimes don't think about and I think are a little far-fetched for litigation. But, you know, if my 12 or 17-year-olds were here, they could probably hook up their iPod to my computer, take down whatever they wanted to take down, you know, other than what was you know, saved and protected, and walk right out the door with it. I probably couldn't do what they could do, but a number of clients have very sophisticated individuals, and some people, when they forget to work on something in the office, in order to take it home, they put it places. So it's just something that we have to be cognizant of. So early assessment, when you don't have a litigation, is easy. You can get all your ducks in a row. But what happens once the litigation hits? The early assessment, it's obvious, I think, to state. I don't want to state the obvious because probably most of you out there are smarter than I am, but you have to understand your case. You have to know who's involved in the case. It's really important to determine the custodians of who will have relevant documents very early on. And I like to categorize custodians as individuals who may have relevant information, and then key custodians, the most important custodians of the most important relevant information. Those are the people you have to hit first. You have to get everything preserved, especially as to the key custodians. Oftentimes, when you get in the middle of a litigation, that little piece falls through. Immediately, you need to understand what's the issues and who are the custodians. And then when we're talking about issues, it's important, in my mind, to say both the offensive issues and the defensive issues. So what will the other side be looking for? What do we need to be preserving here? And then what do we need? Because oftentimes we get so caught up in figuring out how to produce what's being asked for that we forget, wait a minute, the diamond in the rough may be something that we have in our systems that we need to get to, and how are we going to get to that? So who has what? And where do we get that information from? You know, it depends on the sophistication of the client. Is there an IT department? Is there a human resources department? Usually that would be where you would start. But some companies don't have either of those, which makes it trickier. And then we have to determine, are the important files still accessible? I mean, obviously, depending on the age of the litigation and when the events occurred will be somewhat dependent on where we're looking as well. Are things in archives? Are there legacy systems that actually would have to be rebooted in order to get the information? Is that going to be considered inaccessible? Probably. What is accessible versus inaccessible? Accessible really is that data in the machine is in a readable format. So it's active online data and even some offline storage and archives, but it has to be readily usable. So it has to be in a format that you can basically get to, do your searches, and get to it. Under the Zubilecki case, I think it was the second one, that's how the judge defined accessible. Inaccessible, on the other hand, would include backup tapes, would include erased or fragmented or damaged data. So that would be inaccessible. And that is much more difficult to get, much more expensive. And normally, when you're talking about inaccessible data, often there's a fee shifting as to who pays for that. But that's probably a whole separate seminar. But just in terms of when you're trying to figure out where things are, who has them, what are you looking for? In addition to that, do you have a clear understanding of the computer system? Is the metadata going to be relevant? In some cases it is, and some cases it's not. And by metadata, I mean the underlying information about the documents. Who received them? When were they drafted? All of the information that you can't get off a piece of paper, you can get off your computer system, right? So you can tell who created what document, when, who made changes, how, who received it, who didn't. Sometimes that's relevant. Sometimes it's not. From a budgetary standpoint, it's important to know the difference between, do you care about the metadata or don't you? Because it's more expensive, obviously, to deal with metadata than it is to deal with, you know, PDF or TIFF imaged copies of electronic data. So if the metadata is not going to be important in a case, maybe the parties can agree that we don't care about it. If it is going to be important, then it's important early on to figure out how to handle it and how to deal with it, especially from a budgetary standpoint. And then what should be inspected, and I showed you the slide earlier of all the different types, I'll show it to you again, of devices that might be where you might be looking for data. And then finally, and very important, is how much time is going to be required to collect, process, review, redact, and produce. And that's such an important question when you're walking into the initial scheduling conference, especially in federal court, because everything drives from that. The schedule drives from that. It's unrealistic to think you're going to get, thousands of electronically stored documents over to the other side within 30 days. It's not going to happen. So you have to think through with your client early on the time that's going to be required, what it's going to entail. And we'll talk more as we get into it, but the review is significant. And now are we doing manual reviews? Are we doing electronic reviews, computer-assisted reviews? All of that's going to play into the timing and to the budget. And it's important to understand what all the options are. So as you're going through this early assessment process, it's important to ask the right questions. What's the email retention policy? Very significant. Where are documents stored? We talked about it already twice. Is there a shared server so that everything can be pulled from one spot? Or does each individual employee keep their documents separately on their own computer or their own laptop? Or is it stored to a universal server where the IT department, or if there is no IT department, an outside vendor can go to pull the documents from one spot? Important. How long do you keep backup tapes? Very important. And in addition to those questions, well, there's tons of questions, and I'm just giving you a few. But can your employees create personal archives? Can they move things from the main server into little folders that nobody knows about? Do you have an obligation to look at those areas? It really depends. It depends on what you're looking for. It depends on whether that's a key custodian. It depends on whether there are key issues involved in the case. It's also important to know what IT does when it receives a litigation hold notice. Now, it may be that your client has been involved in other matters and already has a process in place. But you need to understand exactly what they do and how do they handle their litigation hold. And if they don't, if it's the very first time, then it's really, in my mind, up to you to work them through that. If they already have a protocol, you just need to understand it. If they don't have a protocol, you need to create it. I was just yesterday working with a client who, frankly, is a very sophisticated client, has a very sophisticated IT department, and when I asked them for their litigation hold protocol, their litigation hold protocol was, in my mind, sketchy. And frankly, when I looked through everything, I knew, based on my understanding that I had gained over this past week of their systems, that they could not be compliant with what they said they were doing. And in fact, they weren't. So we scratched that litigation hold protocol, and when I get done this, we'll be sending out the revised one for IT and HR to sign off on, because it was obvious when I looked at it that it was impossible to follow based on the way their system works. And, it surprises me sometimes when you see the sophistication of some of these IT people, but they don't really understand the discovery pieces of this. And then finally, where is each of the custodians' servers hosted? So, for example, there was a case a number of years ago now, and I don't remember the exact states involved. I want to say it was Florida and Texas, but the HR director found out about an employment discrimination case, handled it to the book, put the litigation hold in place, sent the notices out to everybody involved, and lo and behold, you read the decision and they were sanctioned. And you say, well, what happened? Well, what happened was the individual custodian's computer was in Florida, but the server that her computer was hooked to was in Texas. And so they saved and preserved everything on the Florida server, but didn't do the Texas server. So all of her documents ultimately were gone. So it's a tricky situation, and most clients maybe hopefully don't have that situation, but it's one that if you do have it, you better know early on. And finally, ask the right people. If you ask, I would ask you to do this. If you ask the HR manager, the practice support director, and an IT director all the same question, you may very well get 3 different answers. So if you say, how often do you do backups? The HR person will tell you what they know, which is, oh, we back up every day, we back up daily. But then if you go to the practice support, they may tell you the same thing, or they may tell you what's a little more accurate. Well, we back up daily, but then at the end of the week it's overridden. And then if you get to the IT director may tell you, well, we back up daily, it's overridden at the end of the week, or we do a monthly snapshot, we keep 12 months worth, so basically we have a year's worth at any given time. And if you've asked that question, as I have, to a number of different clients, it's amazing how 3 or 4 people in the same company will give you the different information. And it's easy when it's in writing, you can read it. But, you know, most companies don't have a very sophisticated policy like that. So you're sort of figuring it out as you go. So it's important to ask the right questions. Now, I love this slide. This slide is what I call the corporate enterprise network. And what this slide could mean is just about any company in the world. It could be a very small mom-and-pop company with 10 different employees who have a laptop and maybe a PDA and something else. Or it could be a worldwide company that has servers all over the world. It depends how the corporation's electronic systems are set up for you to know what you're dealing with. You know, it could be one office location with several servers, or it can be an international company with 3 servers. It depends. It depends how they've set up their systems. And it's important for you to know and understand that when you're handling litigations involving electronically stored information. But I'm probably not telling you anything you don't already know. More backdrop. Preservation phase, phase 2. Once you have your assessment in place, preservation has to happen relatively early. There's a duty to ensure that relevant data is not inadvertently destroyed. And with electronically stored information, often companies have certain purging systems. Every month things get deleted, or every 6 months, or whatever they have. And you have to make sure that you're doing your best to prevent documents, relevant data, from being destroyed if you can avoid it. You don't have to save everything, but you do have to make a good faith effort to preserve the relevant. And there's often a balance that occurs. You have to balance the business issues and the costs against the legal requirement. And the rules do offer limited safe harbors and protections against sanctions if you're taking good faith steps to preserve. But it's important to take those good faith steps. And the only way you can do that is if you understand the systems. And, of course, issue the right preservations. So what are the right preservations? A formal preservation procedure is significant, especially if later on down the road there's a question as to what you did and how you did it. It's important to have a formal procedure. It's important to formalize instructions to the employees in writing and to monitor the preservation efforts. Cases go on for a very long time. People come, people go, right? So you have a situation where you have maybe 2 or 3 different HR directors in the time frame that you're handling one litigation or one long litigation. You have to make sure you periodically check the efforts and make sure that everything is being handled properly. Early on during the preservation phase, before you issue the litigation hold letters, again, identify the key custodians. The better you understand who they are, the better your preservation will be. Identify the locations of the data storage devices. The more planning you do in the beginning, the better off you are here. You'll understand where it is that you have to be saving. And then, of course, you have to factor the cost of e-discovery in a litigation budget, because the factors of e-discovery, in my view, are driving settlements. Up or down, they're driving settlements. And they are one of the reasons, one of the things you can use to drive settlements, depending on which way you want it to go. And let's talk a little bit, since we're on preservation, about a proper litigation hold notice. It should be written for the audience that it's receiving. Generally speaking, you're not writing to other lawyers. You're writing to people that may be far smarter than we are, but in a different area. So engineers are not going to understand legalese. File clerks are not going to understand legalese. These letters need to be clear and concise, and they need to be addressed to the specific custodians. The rules the case law is coming out that they want the specific custodians to get a letter. They want you to address the specific types of documents, the specific date ranges, the specific topics. And it needs to be realistic, and of course it needs to be properly followed. And frankly, a lot of times in-house counsel will want to draft the preservation letter, which is fine. But I've seen some pretty awful preservation letters, and it's very important when you have to stand up to criticism later that the preservation letter that went out the door was the right one, that it was formatted the right way. A form or a template is not always going to work. In fact, in our office we have, a form litigation hold letter, but right at the top in big bold letters it says, this is a template. Do not use it without specifics. And it's something that, we know better now, but initially those litigation hold notices that were going out 3-4 years ago were much more general than they are now. They need to be very case specific. So if you ask someone in your office to draft a litigation hold letter, make sure that person understands and knows the facts, the custodians, and everything about that they need to in order to put the right information in that lit hold letter. Custodians should acknowledge their receipt, right? And IT should acknowledge and document everything that they have done. It can be very sophisticated and it can be not so sophisticated. But at the end of the day, 4 years from now, when you have to defend why certain documents are not in the production, it's important to be able to go back and look at the documented sort of chain of custody and information that you have and that was followed. I would say retain all communications with custodians throughout the case. And if you can, put it to a mailbox or house all the communications in one area so that it's clear that the IT person or the HR director and you have access to that and can follow along. Create a regularly scheduled event to reiterate the litigation legal hold, whether it's every 6 months, whether it's once a year, whether it's every other month, however you want to do it, depending on the length of the case and the number of people involved. You should be periodically reminding everybody about the litigation hold. Nobody remembers they received a letter 4 years ago about something. Periodic meetings with departmental representatives, I think, is important. When a case goes on for years, like I said, people change, policy change, and you should be, as outside counsel, periodically reviewing that with the client. And then finally, and most importantly, confirm that you've complied with the protocol. Again, there's nothing worse. The only thing worse than no protocol is a protocol that you're not following. Phase 3, ESI Collection and Production. Again, it probably is what takes the most time and the most energy of us when we're in the middle of a litigation, but hopefully if the early assessment and the preservation was done properly, this piece should not be as difficult. What becomes difficult is figuring out how you want to do it. And that's somewhat part of the early assessment as well. So the timing of discovery, the collection, and the production is something that should be thought through from day one. The scope of the collection is also very important. How are you going to do the collection? How are you going to figure out what's relevant? Are you going to use search terms? Are you going to take each of the custodians' mailboxes and search terms? Are you going to just take the key custodians and use those as a sample and then figure out what words are important and use those? Or are you going to turn to what's more recently now been approved, and we'll get into this in a minute, more of a technology-assisted review, using computers to do the review, to determine the relevant documents? What's the review process going to be? Who's going to do it? Outside counsel? Are you going to have your firm do it? Are your paralegals going to do it? Are you going to hire outside third-party contract lawyers to do it? Or are you going to use a computer-categorized documents and use what is now being termed as technology-assisted review or predictive coding? And before we get too much further into this, I just want to make sure that everybody understands what that means. And predictive coding is essentially a computer-assisted review that uses algorithms to identify, organize, and prioritize documents. And basically it's measured statistically. So it's machine learning technology. It incorporates workflow, it incorporates keyword searches, filtering, but it's all done by the computer. And the computer basically categorizes documents and then refines them by matching them up to the key documents. Obviously, computers can't exist totally on their own, so the lawyers do have an important role in evaluating what's being sort of spit out by the computer. But the courts are now allowing lawyers to use predictive coding and technology-assisted review in order to cut down on some costs and to narrow the scope of what has to actually be eyeballed by the lawyers. A little scary in a way, but I have seen the statistics on the decrease in the amount of money that clients are spending when they're using this predictive coding. It'll be interesting to see where it all goes since it's so relatively new, but it's certainly an option out there and one that you need to fully understand and evaluate when you're talking to your client about how to manage this litigation and how to manage the budget. So all the production options that you need to be thinking about are how you're going to produce what method, what's the budget of review and production, and of course that will be swung high or low based on how you decide to do it, who will be bearing the costs, and how will you handle privileges or inadvertent productions. If we had more time, we could probably get into a significant amount of time on the various orders that the courts are entering, including all of this in the e-discovery orders. And maybe another day we can have discuss that, but that's something I think would take its own hour. But that's all issues that have to be thought through and looked at when you're trying to figure out how you're going to be doing your collection and production phase. Along with that, and very important, is your selection of your team of experts. So are you going to consider hiring outside experts to assist in the effort? And who will work closely with your lawyers? Some of the factors in determining whether to retain outside e-discovery vendors. What's their experience? What's their familiarity with the forensic tools? What are they using to get you the documents? What's their capacity to screen high volumes of information? How much do they cost? Do they have the ability to be a witness, to give testimony? Are they going to come with you into court and explain the procedure and the process? And are they able to identify what's accessible and retrieve what's inaccessible information? All issues that you need to think through. Now, I will say that, years ago when we first started doing e-discovery, all the vendors came out of the woodwork, right? So you had to figure out which ones were good and which ones weren't, and that's a process. We have now here at our office, we have an approved vendor list, and we only will recommend to our clients various vendors from that list. With the new huge predictive coding surge right now, those vendors are now starting to come out of the woodwork, and I would say it's very important to really vet those well. I am certainly agreeable that outside experts are very significant and very important and probably can help you through a lot if you have the right one, but I've also seen where, outside experts end up costing your client more money than they're worth if they're not the right expert and you've not vetted the factors really carefully. One of the things that you have to talk about with your client is whether there's going to be self-collection, meaning that the client and you will be doing the collection, or whether you're going to bring in an outside expert, outside vendor to assist in that. So it's important because if data that's not properly handled, you can result in all kinds of issues. You can end up spoliating evidence, inadvertent evidence corruption. If you don't have the right procedures in place, you can have a lack of proper chain of custody. And then, of course, you have big problems with the collection itself. Either it's too broad or it's too narrow, and if you have to redo the whole thing, it's going to end up costing you more than if you had done it right the first time with an outside expert. So I do think it depends very much on the sophistication of the IT department, your personal comfort level in supervising that, and whether you have the right team of people around you to help you through it and to help your client through it. And if anybody wants to speak separately about that, certainly give me a call because I've done it both ways, and done it with a variety of different outside vendors, and I have some very good, nice stories that worked out wonderfully, and some more stories that I would frankly not care to share publicly, but we worked it out. And it's interesting because, you know, it really does. You really do learn who knows what they're doing in the industry and who doesn't. But you can't do it at the expense of your clients. So it's important to make sure that you vetted these outside experts very carefully. So now let's talk a little bit about the trends. So that's the strategies. So to recap the strategies, and then we'll get into the trends, sorry. 3 phases: early assessment, preservation, and then, of course, the collection and production. All of the strategies are very contingent upon the state-of-the-art that's out there right now and how you're going to handle and manage the litigation. And I can't stress enough that so much of that drives the cost and drives the budget, which ultimately drives what your client wants you to do in a litigation. The numbers are sometimes staggering, and it's scary to a client to know what it would cost. And, you know, frankly, there are some cases that just don't warrant e-discovery, but that's where the documents are. So you have a client that says, you know, this is a $100,000 case. Why are you telling me I have to spend $60,000 in e-discovery? That's a problem. That's a problem you don't really want to have. So you have to figure out how to do it and comply with the rules within a budget that makes sense for the particular litigation. So in light of that, what are we seeing? And what I wanted to do for the last 10 or 15 minutes is look at last year in review, what 2012 focused on. And really the decisions that we saw coming out in 2012 dealt, in my mind, with really 3 major areas. One was the sanctions area, which has been a hot topic since day one. 2, the procedural disputes and how parties and lawyers are handling both the preservation and the collection and production side of things. And then, of course, the latest decisions on the technology-assisted review. And those, in my mind, were sort of the 3 areas that jumped out at me the most. The sanctions one are always the ones that scare everyone the most, so we'll deal with those first. In the Coquina case, for example, the court found that counsel has to appropriately understand the client's data before preservation or collection, which makes me sound really smart, right? Because that's what I've been saying since we started this seminar. Basically, in that case, the court said there was too many too many Indians and not enough chiefs, or too many cooks and not a head cook in the kitchen, or something like that. I forget exactly the words that he used. But basically, there were 15 in-house lawyers. None of them adequately supervised the outside counsel. TD Bank had outside attorneys that were sanctioned. TD Bank was sanctioned. And it was all based on the fact that, frankly, nobody really knew what was in the electronic production. It did not seem, based on the way the ruling and based on the opinion, that anybody had a really good grasp of the early assessment or the preservation that was done. And in fact, one of the big issues was a document that in its native format, and by native format I mean the format that you would get right out of the computer so you could see everything, all the metadata, everything, had red lines, red cautions, and that document was stored electronically. If they had produced that, the other side would have seen the red banner that was like high risk or something, the wording was. But they didn't do that. They produced it not in electronic format, but they produced it in a hard copy or a PDF or something, and it was black and white, and the banners weren't on there. So it wasn't until much into the litigation that everybody realized that these electronic documents had not been appropriately preserved and produced. And so there were sanctions issued in this case, and the court really, what they really were saying is that, you know, counsel has to understand the client's data, and everybody took a hit on that one, both the client and the outside lawyers. And it was certainly, if you read that case, it's interesting how all those attorneys could be involved, and you know, it was really a mess. The other 2 cases, and really they came down the opposite, were regarding litigation holds. One case, Chin versus Port Authority, said that the failure to institute a litigation hold notice is not negligence per se. and that it's only one factor in determining sanctions. And in that case, the court found that the adverse inference was not appropriate because they said that the folders that were lost or missing as a result did not really amount to much. It was minimal. In the New York Appellate Division decision, however, VOOM Holdings, they found the opposite, that the failure to institute a litigation hold and suspend deletion of emails was gross negligence and did, in fact, warrant severe sanctions. So in that case, for example, at the time that there was reasonably anticipated litigation, no litigation hold was placed. And then at the time, 4 months into the case, still no steps had been taken to prevent the purging of emails. And in that case, the court said, gross negligence, warrant sanctions, you didn't implement the litigation hold on time, you should have done it when you anticipated litigation, you certainly should have done it when litigation was filed, and then 4 months later it still wasn't done. So that's why I say early assessment is really very important, and it's very important that you understand the process so that you can get to it right away. And okay, I have a question. And you know what, Steve, I will get to your question in a few minutes, so thank you. It's a little bit long of a question. I'll read it out. I'll just get through this, and then we can get to the questions. So the other area of disputes or decisions that we saw are regarding the search protocols. You know, everybody's trying to figure out what searches to use, how to agree on those. It used to be, I think, that nobody wanted to talk to each other ahead of time and figure out the searching. So in the first few years of the e-discovery boom, I think it was more about trying to get everybody to talk and meet and confer and figure things out. Now, I think parties and lawyers know that it's the most expedient way to handle it, but now the dispute is, well, what's the right search protocols? What are the right keyword searches? So now we fight about that instead of fighting about not doing it at all. But, you know, I do think that attorneys who practice in this all of the time recognize that it's much easier to get along in this regard to get to the information than it is to fight. Certainly there are obviously issues that you can't agree to and motions are warranted, but not everything because it just makes it so expensive. And if you can agree on protocols, it just gets the job done quicker and easier for the clients. In the Juster case, which was actually a February 11, 2013 case, so it's a little bit out of my year in review, but I wanted to tell you about it. The defendant had moved for a protective order because they did not want to do 67 word searches that the plaintiff had requested. And then they said in the alternative they wanted fee shifting if they were required to do the 67 word searches. The court in that case found that it was reasonable that I think that the defendant the plaintiff had already done 100 word searches for the defendant, that even though there was some argument as to whether the words that were being used were too broad, the court found that it was within reason and that it would get the job done and that the fee should not shift. So the court actually denied the defendant's motion for the protective order, required them to do the 67 word searches, and did not award them fees. So again, it's all about trying to work things out and figure out what's the best way to handle things. And then finally, the third category of cases that we're seeing, and I think we'll see a lot of, are the technology-assisted review cases. The De Silva matter, in my mind, was the most probably unique case in 2012 in that a court actually ruled for the first time that the use of computer-assisted coding or predictive coding was judicially acceptable method to do searching and review and production. So the judge in that case, Judge Peck, said 5 reasons. 1, the parties had agreed to use it, so there was consent in that case. 2, there was a large volume of ESI. 3, he believed that there was a superiority of computer-assisted versus manual and keyword searching. I'm not sure initially that I was a believer in that, but I'm starting to think that there is some truth and value to that. It'll be interesting to see how it comes out. But when you think about it, it does make you nervous to rely on a computer to at least do the initial polls and sets of documents. When you think about it, if you had 10 associates in the room, every associate would probably have a different set of key documents if each of them were to review the same, let's say, 500 documents. So it does give it at least some scientific piece to it. In that case, the court also said that there was a need of cost effectiveness and proportionality, and that the computer-assisted review would be cheaper and make more sense economically. And finally, the judge said that there was a transparency in computer-assisted that you don't get when you have individual review by people. So in that case, the court ordered that the use of computer-assisted coding and predictive coding was acceptable. He did note, however, that it did not mean it was appropriate in all cases, and it did not mean the protocol used in that particular case would work in any other cases. But he, as far as I know, was the first judge that actually ruled about the use of computer-assisted coding. And since that time, we're starting to see more cases coming down that way. In the Virginia Circuit, there was a case that also ruled that use of technology-assisted review was judicially accepted. So that, I think, will be one of the most interesting areas that we see coming out. I think we'll see a lot of vendors coming out with different software for predictive coding and technology-assisted review. I think we're going to, in the next year or two, be dealing with the best practices in using the technology-assisted review and predictive coding protocols. And of course, most of us are just starting to understand that now. And so to figure out the best practices about it, it's very interesting. But again, very important to make sure that you surround yourself with the right experts and the right technology outfits in that regard, because you obviously will be relying a lot on the software and the various abilities and capabilities of the computers. I think the other area that we'll be seeing a good deal of is the application of appropriate training, sampling, and quality control when you're using the technology-assisted review, and frankly, even when you're not, when you're doing the manual and keyword searches. I think we're going to be seeing a lot of fine-tuning on search protocols, and we'll be, in my mind, starting to see a lot more orders coming out from the court that lays out the protocol very specifically so that there's no questions and no fights later on down the road. I think in the federal courts we're starting to see that a lot more now anyway, at least with certain judges, and certainly in New Jersey. And, you know, I think some judges are more adept in the electronically stored information than others, but I do see, at least in the federal court system, that it's becoming much more across the board, where the judges want to see this stuff in the orders and everybody knows from the beginning what the requirements are. State courts, maybe not as much, although depending on what judge you're in front of, I think we'll be seeing it there as well. So I think that's probably what we have in store for us. I think this technology-assisted review and predictive coding protocols will probably be at the forefront on that, and I have a feeling that we will be dealing in our own practices with trying to figure it all out and then figure out what the right ways to handle and whether the manual keyword searching or the computer-assisted is the way to go. So Steve Maddox asked a question: how do you feel with early case assessment with respect to determining as early on as possible whether the claims asserted have merit or whether the client has viable defenses? Found that when you deal with a large volume of documents, you don't know what the case really is about because you don't know what the documents say. It's so true. You can only really get your client's view of it, and that's part of the problem. So when I say early assessment is very critical, I guess what I really should say is early assessment of your client's case is very critical because that's all you can know. And it's difficult. You know, it used to be that you had 10 or 20 key documents in a case, you'd go over them, you would know what they were, and until you, the problem with the volume that we're dealing with right now, and I agree with you, Steve, is that I'm seeing that it's difficult to assess your case in terms of the merits. But I guess what I'm saying is that it's really important to assess what you need to do with your client as early as possible, because you're right, with this volume of documents, it's just a moving target. It's a constant moving target. I have another question. I'm seeing document preservation letters issued by opposing counsel on nearly every new case. Do you do this, or is it implied that preservation of ESI is required? I think that it's implied that preservation of ESI is required. However, in particular, if I don't, I do it. I do not do it, I don't think, on every case. I think it somewhat depends on if there's particular set of documents that I'm most concerned about that I want to make sure that are preserved. I will do a preservation letter early on and make sure that the other side knows very specifically, don't save only what you want to save, but I want to see X. So in that regard, Corey, I do the preservation letters, but you're right. Under the rules, you shouldn't have to. I think it's more a dotting the I's and the crossing of the T's specific to documents that you want to make sure you get, especially if the other side is the only one that has them. If there's any other questions, I think we have about 3 minutes. Okay.
Well, Margaret, as we wait for any possible additional questions, I would just like to thank all of our members for joining today's webinar. And Margaret, a special thank you to you for sharing all of your expertise in this area and also for preparing this informative webinar. And just so you know, all registrants that participated today will receive a follow-up email from Meritas headquarters that will include a link to the recording of today's webinar, a link to a brief survey, as well as a copy of the materials that Margaret put together. So,
and just as an aside, one of the cases, I just realized the Chin versus Port Authority case, there's actually been an F3 citation to it, which is not in my presentation, so maybe we can just include that site correction, Kim, in the email that goes out.
That's great. Okay, unless we have any other final comments, we'll close out the webinar today, and thanks again to everyone for participating.
Thank you.
Margaret, bye-bye.
Thank you. Please stand by.